Welcome back to the Technology Risk Podcast.
It is Friday, January 30th, 2026, and today we are opening up a file that's been sitting on the corner of everyone's desk for a while. But suddenly, as of last week, it's become the most important thing in the room.
We're talking about the collision between, the unstoppable force of efficiency, which is my favorite topic, and the immovable object of the federal court system. Specifically, what happens when AI starts lying in legal filings.
And not just lying, but hallucinating entire realities. It's a massive topic. But before we get into the grim details and the new court orders that are scaring a lot of general counsels right now, we should probably remind you to hit that subscribe button.
That's right. Whether you're listening on Spotify, Apple Podcasts, YouTube Music, or wherever you get your audio, make sure you're subscribed. You really don't want to be the last person to know about the risks we cover here.
Absolutely. So set the scene for us. Why is this on the agenda for today specifically? I mean, we've known AI makes mistakes for years. What changed?
The temperature changed. The catalyst was a formal warning issued just last week on January 21st, 2026. A U.S. federal appeals court, they effectively decided they had seen enough.
And this wasn't just a friendly heads up to the legal community, was it?
No, not at all. It was a shot across the bow. The court issued a statement noting that errors from generative AI in legal filings are increasing rapidly, and they explicitly said judges are done being lenient.
Done, okay.
They're responding with sanctions.
Sanctions. That is the magic word that makes CFOs sweat.
Yeah.
We aren't just talking about a judge scolding you. We're talking about money. Monetary penalties, maybe even striking pleadings from the record.
Exactly. And the critical shift here is that this has moved from, a novelty issue to formal legal exposure. You remember back in 2023, there were those viral stories about the lawyer who cited a fake case involving an airline.
Oh, I do. Everyone had a good laugh about it. It felt like a rookie mistake.
Right. It was treated like a funny anecdote about technology. But fast forward to 2026, and the courts, well, they are not laughing. They're treating this as professional misconduct.
I want to pause here because I can already hear some of our listeners tuning out. We have a lot of tech founders, investors, general business operators. They might be thinking, well, I'm not a litigator. This is a problem for the lawyers.
And if you think that, you are walking right into a trap. That is actually the main reason we wanted to cover this today. The sources we're looking at make it crystal clear. This is not just about lawyers.
It's about anyone who uses AI to generate text that touches any kind of legal obligation.
Exactly. If you're an SMB, a small to medium business, and you're using AI to draft a contract, an HR policy, a compliance document, this ruling affects you.
Which is basically everyone. I mean, look, I'm on the side of speed. In my world, if you aren't using AI to draft your documents, you're wasting time and you're burning cash. Efficiency is everything. I'm constantly telling portfolio companies to automate more.
And that tension is exactly what we need to resolve today. Because efficiency is great, but efficiency that gets you sued is just an expensive mistake. So our mission here is to explain what the courts are actually seeing, why the liability is landing on the user, that means you, and then give you the specific guardrails you need to keep using these tools without getting sanctioned.
Okay, let's start with the what. We've all heard the term hallucination. It's become a bit of a buzzword. But what does that actually look like in a legal context? What are these judges seeing that has them so frustrated?
The numbers are actually pretty startling. We're looking at a report tracking over 120 court cases in just the last 2 years that referenced improper or, erroneous AI-generated filings.
120 cases. That's not a handful of outliers anymore. That is a trend line.
It is. And the errors are incredibly specific. We aren't talking about typos or bad grammar. We are seeing fabricated case law. The AI is literally inventing cases that do not exist.
So basically writing legal fiction.
Exactly. It's creative writing. And here's where it gets insidious. Fake citations. You know how a legal citation has a very rigid, specific format? Volume number, reporter name, page number.
Right. It looks like a secret code if you aren't a lawyer.
The AI nails the format. It looks visually perfect. But if you actually go look up that reference, it's a ghost link. It points to nothing. Or worse, it points to a completely different case about a totally different topic.
That is so dangerous because it passes the eye test. If I'm a busy CEO scanning a document, my brain just assumes it's real.
That is the deception factor. The sources call it confident nonsense. The output uses the right jargon, the right tone, the right formatting. It is authoritative. And it's not just fake cases. We're also seeing what they call incorrect standards.
What does that mean?
So imagine you have an employment dispute in California. California has very specific, very strict labor laws. The AI might confidently apply federal rules to that state case, or it might pull a legal standard from New York and apply it to a contract in Texas.
Which, if you're an HR director relying on that draft to fire someone, is a lawsuit waiting to happen.
A total disaster. And to put a number on this risk, a Reuters analysis found that 23% of reviewed AI-assisted legal drafts contained at least one fabricated citation or incorrect authority.
Wait, hold on. 23%.
Almost 1 in 4.
If my CFO got the math wrong on 25% of our spreadsheets, they would not be my CFO by lunchtime. That is a staggeringly high failure rate for something as binary as, is this a real law or not?
It is. And this brings us to the why. I think a lot of people still have this mental model that AI is like a superpowered search engine, that it's looking up facts.
Right, they think it's retrieving data.
But it's not. And this is the aha moment for the listener. These models are probabilistic token generators. They are predicting the next word in a sequence. They aren't checking a database of truth. They are improvising a sentence that sounds plausible.
So when you ask for a case about, say, breach of contract in a bakery, it doesn't look for a real case. It constructs a sentence that looks like a case about a bakery because those words statistically go together.
Exactly. It is prioritizing fluency over factuality. It wants to give you a smooth, coherent answer. And sometimes the most coherent answer requires inventing a fact to fill a gap.
And that explains the confident part of confident nonsense.
Right. And that is why the judicial stance has hardened so quickly. The court's position is now crystal clear. Using AI does not relieve the filer of the duty to verify accuracy.
So the robot ate my homework is not a valid legal defense.
It's actually worse than that. The courts are saying they don't care how the error happened. They don't care if you didn't know better. They care that you submitted it, you signed it, you own it.
Okay, so we've established the error rate is high, the mechanism is flawed for truth-seeking, and the courts are angry. But I want to dig into the why now aspect. We've had these tools for a few years. Why is 2026 the year this blows up?
It's the shift in usage patterns. If you look back to 2023 or 2024, most professionals were using these tools for research or, brainstorming. Summarize this PDF or give me 5 ideas for a clause.
Right, it was a companion. Help me think.
Exactly. But now, the usage has shifted to drafting. Businesses are using AI to write motions, contracts, and compliance filings from scratch. They are letting the AI hold the pen.
And I get why. I really do. In my world, we're constantly pushing companies to be leaner, do more with less. If I can get a vendor contract drafted in 30 seconds for free versus 3 days with outside counsel at $500 an hour, I'm taking the 30 seconds.
And that economic pressure is real. I'm not dismissing the efficiency. But that creates what we call the trap of Polish, because the output is so instant and looks so good, it creates overconfidence. The AI doesn't hedge. It doesn't say, I think this case applies, but I'm not sure. It just states it as fact.
It's that trade-off between speed and accuracy, and it seems like we're just prioritizing speed.
We have data on that, too. Deloitte released a statistic showing that 61% of SMBs using AI admit they sometimes, or often, skip full verification to save time.
61%, that is terrifying.
It's the majority.
So you have a technology with a 23% hallucination rate and a user base where over 60% aren't checking the work. That is literally a ticking time bomb.
It's a statistical certainty that things will go wrong.
But I want to play devil's advocate here for a second. I can hear some of our listeners thinking, because I hear this in board meetings, okay, sure, but I'm a small business. I'm not Google. If I mess up a citation in a vendor agreement, surely the judge is going to go easy on the little guy.
The small business exception myth. I'm here to tell you, based on every ruling we have reviewed for this, that exception does not exist.
The courts don't grade on a curve.
They absolutely do not. Courts apply the same standard of accuracy to everyone, whether you're a massive conglomerate or a 3-person startup. A bad legal filing is a bad legal filing. The law is binary.
And the impact goes beyond just getting yelled at by a judge in a courtroom, right? Because most businesses try to stay out of court.
Far beyond. Think about the scope of documents. It isn't just litigation, it is NDAs. It's privacy policies. It's regulatory responses.
That's a good point.
Yeah.
If my privacy policy cites a regulation that doesn't exist, and then I get audited by a state attorney general,
You're in deep trouble. It's what we call downstream risk. An error in a contract drafted today might not surface for 6 months, maybe a year. It just sits there. Then you get into a dispute or an audit happens and this is big for your world due diligence for an acquisition happens.
oh, absolutely. If I am looking to buy a company and I find out their core IP assignment contracts are full of hallucinatory legal language,
Yeah.
I'm walking away. Or I'm cutting the valuation in half.
Exactly. The damage is done long before you ever get to court.
So let's talk consequences. We mentioned sanctions. That's cash.
Yes, financial penalties, legal fees to fix the mess, refiling costs. But the one that should scare people more is the reputational damage. Critical judges talk, lawyers talk. If your business becomes known for submitting sloppy, hallucinatory work, your credibility evaporates. In a negotiation, if the other side knows you rely on unchecked AI, they will tear you apart.
And then there's the contract itself.
Contractual risk. Incorrect clauses can invalidate the protections you thought you had. There's a stat from the ABA, the American Bar Association, that says 34% of contract disputes in SMB litigation stem from ambiguous or incorrect language.
A third of disputes come down to just bad writing.
Bad writing that AI is very happy to generate for you if you aren't checking it.
Okay, so we've established the house is on fire, the courts are angry, the robots are hallucinating,
Yeah.
and business owners are skipping the safety checks. Let's pivot to the solution, because I'm not going to stop using AI. I can't. Speed is still essential. So how do we use this technology without the blowback?
You don't have to stop using it, but you have to radically change your process. We've distilled this down to a set of guardrails that every business needs to implement. Like today,
Lay them on me. What's step one?
step 1, role definition. Never, ever let AI be the final author.
Okay.
The best mental model is to treat AI like a brilliant but slightly drunk junior assistant.
I think we've all worked with one of those.
Right. They're fast, they have access to a lot of information, but they are prone to making things up to sound smart. You might let them draft the first pass, but would you ever let that assistant send a final document to a federal judge without you reading it first?
Never. I would check every single word.
That is the rule. Humans must approve everything.
That's a great framing. So the AI is the junior assistant. What's step 2?
Step 2 is mandatory verification. And I mean mandatory. Every statute, every case, every regulation cited must be independently checked.
And when you say independently checked, does that mean asking the AI, are you sure this is right?
No, that's the trap. If you ask an LLM, are you sure? It will often just double down on its lie because it's predicting what you want to hear. You have to go to a primary source, Google the case name, look up the statute code in a real database. If you can't find it outside the chat window, assume it's fake.
Trust, but verify. Or really don't trust, just verify. But isn't that time-consuming?
It takes time, yes, but it takes a lot less time than writing the whole thing from scratch. You're still gaining efficiency, you just aren't gaining reckless speed.
That's a fair distinction. What's step 3?
Step 3, high-risk restrictions. You need to prohibit AI from doing the final draft of high-stakes documents. Court filings, regulatory submissions, that kind of thing.
So if it's going to a judge or a government regulator, a human needs to write that final version.
Yes, the stakes are just too high for automation there. Use the AI to outline it, sure, but you write the sentences?
That makes sense?
Yeah.
What about how we prompt the tool?
That brings us to step 4. Structure versus substance. This is a key distinction. Use AI for formatting, for outlining, for cleaning up messy notes, but do not use it for legal conclusions.
So don't ask it, is this legal?
Right. Don't ask, is this non-compete enforceable in California? Ask it, format this text into a standard Claude structure. Ask it to be a secretary, not a lawyer.
I like that. Structure versus substance. And finally,
Step 5, documentation. Document your review process.
why did that matter?
Because if something slips through, and we're human, errors happen. Courts are far more lenient if you can show you tried. If you can say, Your Honor, here's our log showing we checked these 3 sources and this one error still got by. That looks a lot better than we copied and pasted it and hoped for the best.
It shows good faith.
Yeah,
It shows you aren't just being lazy.
exactly.
So let's make this real. Do we have any examples of how this plays out? Success versus failure? We do. Let's start with the failure. There was a startup scenario recently where they let AI generate a compliance filing verbatim. They were in a rush. They wanted to get it off their desk. Speed mode.
Classic move.
They submitted it. Turns out the AI invented a compliance standard that didn't exist. The errors were found, the filing was rejected, and sanctions were imposed. But the kicker, they end up spending 10 times the money on legal defense and cleanup than they would have spent just hiring a lawyer to review it in the first place.
So speed without verification ended up being the most expensive option.
It always is. But let's look at the success story. We have an SMB that used AI to draft a complex employment agreement. But they applied our guardrails.
The junior assistant rule.
Right. They had the AI draft it. Then they had a human do a source verification line by line. The lawyer did a final review. The result. They still got a faster turnaround than writing it from scratch, but they had 0 disputes.
So AI plus verification equals efficiency?
Exactly. You get the speed benefit without the liability hangover. That is the sweet spot. So looking forward, where does this go from here? Are the models going to stop lying? Or are the rules going to get tighter?
I think we have to expect courts to tighten the rules. We are likely going to see mandatory disclosure of AI use in court. You'll have to check a box saying, yes, AI was used here.
Transparency.
Transparency. And we're going to see the standardization of legal AI governance. Big companies are already doing this, but it will trickle down. You'll need a policy. And finally, AI literacy is going to become a required skill.
What do you mean by AI literacy in this context?
It's not just knowing how to prompt, it's knowing what AI can't do. We spend a lot of time learning its capabilities, but knowing its limitations, knowing it hallucinates cases, knowing it struggles with jurisdictional nuance, that is a professional skill now.
That's a really powerful point.
Yeah.
It isn't just about prompt engineering. It's about output skepticism.
Output skepticism. I love that term. That is exactly what it is. You need to look at the screen and doubt what you're seeing until you prove it's true.
So if we boil this all down for the listener, what is the one thing they need to take away from this conversation?
It's simple. In the eyes of the law, the AI wrote it is not a defense. Accuracy is 100% the human's responsibility. You own the output.
You own the output. It puts the accountability right where it belongs. Well, this has been an eye-opener. I'm definitely going to be double-checking a few documents after this.
Please do. The extra 5 minutes is worth it.
And for everyone listening, if you want to make sure you don't miss out on future discussions like this, where we break down the risks that are actually affecting your business right now, please subscribe. You can find the Technology Risk Podcast on Spotify, Apple Podcasts, YouTube Music, or your preferred platform.
It really helps us out, and it keeps you in the loop.
Thanks for listening, everyone. Stay efficient, but stay verified.
See you next time.